Welcoming for the first time to the Hugh Hewitt Show, Professor Jed Rubenfeld of Yale Law School, where he is among the first rank of American constitutional law scholars. Good morning, Professor. Welcome. Good to have you.
Good morning. Thanks for having me.
I watched your video on former President Trump's appeals and what will be the most meritorious of those many different grounds. I wrote about that yesterday for the Washington Post, my favorite ground of appeal. I'd like you to summarize for our audience your best appeal points for the former president in the Manhattan convictions.
Well, I'd say there were three. I'll name them: selective prosecution, right to notice of your the charges with that the state's coming after you for, and right to jury unanimity. Selective prosecution, in constitutional terms, that refers to a situation where the state or the prosecution comes after somebody on criminal grounds because of their political activity, in retaliation for or out of hostility toward or trying to undermine their political activity. And of course, a lot of people think that's exactly what happened in this case. And if it did happen, that makes the whole prosecution unconstitutional. You're not allowed to do that in this country. And of course, the danger that did happen, that's why this is such a dangerous precedent. And, you cannot have a situation in the United States where elected members from one party are coming after their chief political opponents from the other party. It's just a constitutional and legal disaster. You got to be really careful about that. Every single corner has to be turned squarely. Everything's got to be constitutional. Everything's got to be lawful. Now, the problem, though, for the folks who want to say this was a political prosecution, therefore unconstitutional, it's very hard to prove. Selective prosecution is extremely hard to prove. And often courts demand what they call a comparator, a situation where somebody did something very similar but didn't have the same political views or came from the other party and was not prosecuted. And you're almost never going to find that exact comparison case. But believe it or not, your listeners, viewers may be interested. There might have been such a case here. And that, of course, is the Hillary Clinton campaigns having been found just in 2020 to have done something very similar, an offense remarkably similar to the one that Trump was charged with, namely treating campaign expenses as legal expenses, marking them down as legal expenses, which the FEC determined to have been a violation. Amazingly, that's kind of more or less exactly what Trump was charged with, marking down so-called campaign expenses as legal expenses, and thereby supposedly covering up a campaign finance violation. Well, if the Trump team can prove that on appeal, and they might be able to, that could be the exact kind of comparator case, because that was a New York-based campaign, and New York never came after the Hillary Clinton campaign, not Clinton herself, not anybody in it. They don't seem to have investigated it. They certainly didn't seem to have prosecuted it. Maybe that's the comparator case that could show selective prosecution here. The other two, I'm talking too much here, but the other two grounds of appeal that I mentioned are constitutional grounds about right to notice of charges and unanimity. Tell me what or whether you'd like me to summarize those.
Well, I want to inject, of course, my own view first and get your response to it. I wrote this for the Post yesterday. And I live in a bunch of different worlds, Professor. I don't expect you to know this. I'm retired from the active practice of law. I still teach constitutional law at Chapman Law School, and I write and I broadcast. I wrote for the Post yesterday, the number one reason Trump should win on appeal is that Judge Merchan should never have accepted the case. And I realized that the advisory committee said he didn't have to recuse himself. And I realized the Court of Appeals kind of said, don't worry, on the recusal motion. There was an interlocutory appeal there. But subsequent events provide the clarity of conflict, I think, that should have taken Judge Merchan off of this case for his $35 total contribution. And I'm so adamant about this because in California, where I practiced for 30 years, no judge makes any contribution ever. And I went and looked up the New York law. It's prohibited explicitly in New York law to make a political contribution. What do you think of that on appeal?
Well, I think you're right about what you just said about New York law. Judges are not permitted to make political donations. So, Merchan was, I think clearly in violation of at least judicial ethics rules in New York. Was he required by law to recuse himself? Did he have the kind of conflict of interest which legally required him to recuse? I'm not sure. Hugh, I agree with you, though. In a case of this magnitude, of this importance, where impartiality was so important, the appearance of impartiality was so important to the country, if you ask me, should he have recused himself? Well, boy, I think months and months ago he probably should have. And you haven't even mentioned that he has a daughter, a grown daughter, who has a business that allegedly, makes a lot of money from campaigns on the other side of the aisle. The Biden Harris campaign's a client of hers. And folks point to that as a potential source of conflict, too. They claim that his daughter is making a lot of money from an outcome in this case where Trump loses. So
yeah, I put that aside largely because evidence of that is not in the record, but evidence of the $35 is. Let's move to the one that is the easiest. Not the reason why I think it should be, because I'd like to set a standard for all judges going forward. If you've made a contribution, don't even get near a case. But let's talk about failure to specify in the indictment the crime with which you're being prosecuted. I really cannot understand how that got to first base.
Yeah, it's pretty shocking. I mean, you ask anybody on the street right now, okay, you undoubtedly have heard that former President Trump has been convicted on 34 counts of a felony. Tell me what he was convicted of. What's the crime? I'll bet 99.9% of people can't tell you what crime he was convicted of. And then you ask lawyers, and it turns out 95% of them can't tell you what he's convicted of. That is very unusual. I mean, normally, as you know, in a criminal case, somebody's charged with robbing a bank on a certain day, and if the jury enters a guilty verdict, what they've been found guilty of: bank robbery, of such and such a bank on a certain day. That is not true here. That's because the charge is so complicated. So he's charged with falsifying a business record. That's the business about the legal expenses, in order to conceal a second crime. And the state never made clear, right up to the day of the trial, exactly which crime they were claiming was going to be the second crime. They tried to leave it open. At a minimum, there were three theories, but one of their theories of the second crime was a New York election law violation. That's the one they end up settling on and going after. That's going to be the crime that he tried to conceal, supposedly. But that New York election crime, guess what? That's a crime that says it's a crime to try to influence an election through unlawful means. In other words, you can't violate that statute without committing a third offense. So we've got a third offense. We got a nested crime with three offenses. And that third one, they never specified. Right up until the last day of trial, the judge told the jury, hey, there could be at least three different theories of what the unlawful means were.
I also think on the failure to specify a crime, I don't even think they made that statement until after the defense had rested. Am I right about that?
They did not say that it was definitely that crime number two was going to be the election crime until very, very late in the day. They certainly didn't say it before the trial. And as you know, Hugh, the whole point of the constitutional right is you're supposed to be notified of the charge you're facing before the trial, not toward the end, because you're supposed to have a right to prepare your defense. You're supposed to know what they're going to throw at you so you can defend yourself. It's not enough for the judge and the prosecution to say, okay, toward the end of the trial, now we're going to tell you exactly what we're charging you with. That is not, how it's supposed to be done constitutionally.
How many years did you spend prosecuting, Professor?
Just a year and a half. I was only there for about a year and a half, maybe a few months more.
You have an infinite more amount of experience than I do. So I'm going to count on you to tell me a little bit about this jury instruction. I read the jury instructions and I heard him say 444. How does that possibly add up to a constitutional process?
Oh, I'm not sure it does. As you told your listener, this is complicated business, but just try to make it as clear as I can. So, I was saying just a couple minutes ago that what we've got is a nested crime here, three different crimes. The allegation is, Mr. Trump, you falsified business records in order to conceal a second crime. That second crime was a New York election law offense. That New York election law offense was trying to promote your own election through unlawful means. What were the unlawful means? Well, there's at least four possibilities. This is what the judge is telling the jury. Four possibilities. Could be a New York tax law offense, could be a federal tax law offense, could be a New York business records offense, could be a campaign finance violation. The judge threw out all those theories to the jury, and then he said, and you don't have to be unanimous. 3 of you can think it was the campaign finance violation. 3 of you can think it was a New York tax violation. And 3 of you could think one thing and 3 of you could think another. And you can convict them with that unanimity. Now, the Constitution of the United States, Sixth Amendment, says that in every jury trial, the defendant has a right to a unanimous jury verdict on every element of the offense. Well, it sure looks like that's a material element of the offense. In fact, the law is pretty clear on this. And if you want, Hugh, I can give you an example of a similar case. Okay, so again, a little complicated, but we've got a federal statute called the RICO statute. The RICO statute, you may have heard of it, racketeering statute. Here's something that's illegal under the RICO statute: conspiring to run an enterprise through illegal conduct. Okay, that's similar to the Trump charge. He's charged with conspiring to influence an election through illegal conduct. So you get lots of these prosecutions under RICO. Hey, you guys were conspiring to run an enterprise, could be a business, a union, whatever, through illegal conduct. And in a lot of those cases, the government comes in and says, hey, we're going to throw out a whole bunch of possible theories of illegal conduct to the jury, and we'll let them decide, and they don't have to be unanimous. Well, guess what? The courts have rejected that over and over, including in the Second Circuit. They said, no. Okay, you could have different possible facts, brute facts, that's what the law calls them, but you got to decide, and the jury has to be unanimous. Are you saying that he was running the enterprise through, murders, acts of embezzlement, acts of robbery, with respect to the kinds of crime? You cannot have the jury saying, 4 of them say, oh, they were running the enterprise through acts of murder, 4th say through acts of robbery, 4th say through acts of embezzlement. With respect to the kind of crime at issue, there must be unanimity. And that's a conspiracy charge, kind of like this one. And that's exactly what Merchan said. You don't have to be unanimous.
I do think that's the slam dunk, in my opinion, when they get to a federal court. Back in the Paleolithic age, Mark Levin and I were working for Ed Meese at Justice. Mark was the chief of staff. I'd been there with Bill Smith, and I stayed with Ed Meese as the FISA special assistant. But we all kind of knew what we were talking about. Mark talks about extraordinary writs, and I don't have any idea what he's talking about. He's very smart. Can this get to the federal courts before the New York appeals process is exhausted?
I think it can. It's tough. It's a uphill battle. There's 2 ways. Trump's lawyers could go to federal court right now, today, and they could bring an action, a Section 1983 action, and they would say to the federal court, hey, hang on, there's going to be irreparable harm. If you allow Judge Merchan on July 11th, that's when sentencing is scheduled, to enter a judgment of guilt, which he's very likely to do on that day, and sentence former President Trump to either probation at a minimum or to incarceration, there's going to be threatened irreparable harm to the election. And to stop that irreparable harm to the election, we need to put a pause on those New York proceedings, and we need a fair federal tribunal to hear these serious constitutional objections and tell the country, was the Constitution violated in this case? Because if the election is affected, maybe even swung by an unconstitutional conviction, that's irreparable harm. That's New York doing damage, legal damage to the country. And if you let it go through the appellate process, even if it gets reversed a couple of years from now, you cannot undo that irreparable harm.
Professor, let me interject here, because we have Steelers fans listening, and they're a little bit slow. 18 U.S.C. 1983 is a cause of action that lies when, under color of state law, a state actor interferes with your constitutional rights. I'm very conversant with that. I'm not conversant with the extraordinary writs that Mark knows a lot about. Has a 1983 action ever successfully stopped an entry of judgment?
Well, great question. I mean, I got to tell you something else that's a problem with the case is that there's a specific doctrine called the Younger abstention doctrine, that's the name of it, that says, hey, federal courts, normally you cannot interfere with state criminal proceedings. It's very specific. It comes from the Supreme Court, and it says to federal district courts, if there's a state criminal proceeding going on and you're being asked to pause it or interfere with it or reverse it, or you just can't. You can't hear that case. But so that's why you almost never see these cases. But the Younger doctrine, the Supreme Court's been very clear, does not apply in, quote, exceptional circumstances where serious and imminent irreparable harm is threatened.
Oh, my goodness.
It's hard to imagine a more exceptional case.
Yeah, I did not know about I don't teach Crim Pro. I don't get near it, and I don't remember 1983 when Jerry Israel taught me Crim Pro. But I do believe this is about as exceptional a set of circumstances that any court could want. It's at least worth a swing at the plate. I'm afraid if you go to the Supreme Court on an extraordinary writ and you don't get it granted, it looks bad for the former president. And I don't think they would grant it. Do you?
Well, you're putting your finger on the double issue here for the Trump team. They've got, you said look bad. You always, lawyers are always going to look at PR issues, public relations. They're not just going to be asking the legal issues. You and I are talking about the law. But yes, any sensible lawyer is going to be thinking, hey, let's say we're swinging for the fences and let's say we got a 10% shot. What's the downside? Well, they're going to be asking themselves the question of the downside. What does it look like if they get turned down? Will the public understand that all the court's saying is, you know what, we think it's not time yet for us to look at this case? Or will the public see it as validation of the conviction? And I'm sure the Trump lawyers are thinking, hey, we don't want a PR disaster on our hands. With respect to the All Writs Act, which Mark was talking about, that's pretty complicated. And I'm happy to say more about it if you want, but it gets pretty complicated.
Next time, Professor, because I got to go. But I really appreciate your time this morning. I look forward to having you back because I thought your presentation on YouTube was the most coherent and concise presentation by any academic yet about this. I've heard some good lawyering from Andy McCarthy and some good lawyering from Jonathan Turley, but I thought yours was exceptional, and I appreciate your making time for me this morning. I'm going to reverse my blockade on Yale law graduates going to work for me. I've always had that blockade in place. I don't think you guys actually teach them anything, but they show up, they're very smart, and they're very, very conversant.
I try.
But when I've taught them how to practice law, it's a little bit different. Professor Jed Rubenfeld, thank you for joining me this morning.
Thanks for having me, Hugh. And I do teach my students law, I promise you.
Oh, good. I'm glad to know that.